If you would all please join me before we start in saying the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Good morning, everyone, and welcome to our subcommittee work session, ongoing session regarding bail reform. Today, we're going to be discussing the actual list of crimes that we're contemplating being not bailable by a bail commissioner. And you just give me a minute to call it up. We will start with that. A few housekeeping things first. This is for the members of the committee. Right now, I'm working on setting up a meeting with the Chief Justice of the Supreme Court to discuss our bail issues. In keeping with my commitment to make sure this is a nonpartisan event, I will be taking a member. Probably I'm going to ask Representative Gathright to attend or Representative Muse. I'm also working on a meeting, hopefully next week, with the Attorney General. Same thing applies. I've asked that the attorneys for the county come and join us. And I've also extending an invitation to the public defenders to come and talk to us. Each of these things that I've mentioned are all part of this bail reform. There's so many moving parts. So we all have to keep in mind that any change we do, however small to this, affects 4 or 5 different parts of our criminal justice system. And each one of those within their agencies are affected. So it's very complex, a lot of moving parts. So we have to be very deliberative in what we do. For example, if we contemplate having judges hear cases on a weekend, you think, okay, the judge has to be able to come in or do a Zoom hearing on the weekend. Well, not just the judge, it's also the clerks. The clerks have to be able to take notes of everything that's happening to enter into their systems. The clerks are union. To have them work on the weekend, it's going to cause impact bargaining to open up their contract. Very complex stuff. So that's why it's important that we discuss and invite as many people as we can so that we understand the long-range implications of every little change we make. So let's talk about crimes. And if I could just find that list. Is that the one from the Senate? Because it will. Okay. Yeah, okay. Very good. Thank you so much. All right. So I'm going to be working off the SB 252 as proposed by the Senate. And we're going to look at their list of crimes that they would like to be not bailable by a bail commissioner. And the first on the list is a person charged with homicide. I don't think we really have to include that because it's already got its own statute and it's not bailable. So we can probably just cross that one off. Anyone have any thoughts on that? Anyone?
Is there a disadvantage to putting it on there, making it redundant?
No, there's not. Other than the fact that it makes us look like we didn't know it was already there. But we can leave it for now and put a pin in it and talk about it when we draft the final one if you want. What's that?
No, he has a 252.
SB 252. And the next one we talk about is first degree assault under RSA 631. Can you call that statute up so as we go along we can actually read it? RSA 631. 1. Could you would you read it for us?
Yep. RSA 631-1, first degree assault. A person is guilty of a Class A felony if he or she, I will go ahead and add that, purposely causes serious bodily injury to another, or purposely or knowingly causes bodily injury to another by means of a deadly weapon, except that if that deadly weapon is a firearm, he shall be sentenced in accordance with RSA 651-2. Purposely or knowingly causes injury to another resulting in a miscarriage or a stillbirth, or knowingly or recklessly causes serious bodily injury to a person under 13 years of age in this section. And then it goes on to describe a miscarriage or a stillbirth.
Thank you. So the question for us is, does that crime in and of itself characterize or lead one to believe that that person, were they released, would be a danger to the public? I tend to agree that that's a very serious and violent crime, and it should be heard by a judge and not released by a bail commissioner. What are the committee's thoughts? Representative Muse.
Yes, as we go through this, it would be very helpful if when we're looking at the statute, we could just also mention what the penalty is. So for this one, it's obviously a felony. Some of the others, it's not so obvious. So it would just be helpful if we just mention that going forward.
Agreed. We will make sure we call out whether it's a felony or not, or if a certain degree of it is a felony. Because some of them, for example, stalking, have a misdemeanor level and a felony level. So we'll call that out as we go. With regard to this one, so anyone else? Representative Stone.
Mr. Chairman, I would concur with your assessment of it.
Everyone seems in agreement. That one's pretty clear cut. The next one is RSA, second degree assault, RSA 631-2.
Okay, 631-2, second degree assault. A person is guilty of a Class B felony if he or she knowingly or recklessly causes serious bodily injury to another, or recklessly causes bodily injury to another by means of a deadly weapon, except if that deadly weapon is a firearm, he or she shall be sentenced in, looks like section 2, recklessly causes bodily injury to another under circumstances manifesting extreme indifference to the value of human life, or purposely or knowingly causes bodily injury to a child under 13 years of age, recklessly or negligently causes injury to another resulting in miscarriage or stillbirth, or purposely or knowingly engages in the strangulation of another. In this section, and then it goes on to describe miscarriage, stillbirth, and strangulation. Mr. Chairman, it does go on to say, upon proof that the victim and defendant were intimate partners or family of household members, or those terms are defined in RSA 632B, shall be recorded as second degree assault under the domestic violence.
Thank you. So it seems to me that the element that's different in this one is it's reckless versus intentional. Can you read that part again? That it talks about indifference.
Yeah, hold on one second. Let me find it. Please hold. Wait, I can't find it now. Okay, it's under C. Recklessly causes bodily injury to another under circumstances manifesting extreme indifference to the value of human life.
Thank you. Any thoughts on this one? So this also seems very serious versus planning it out or intentionally. Someone did something so reckless that that a normal person would never contemplate doing something like that. And in doing such an act, they caused serious bodily injury to another person. Again, someone who was so reckless that they caused such serious bodily injury, in my mind, raises serious questions about their ability to maintain themselves in good order and not be a danger to the public due to their recklessness in whatever the case is. It's a felony. Let's hear some thoughts from the committee. Representative Muse.
One of the things as we go through this list, I think pretty much looking at this list, I mean, I think we would probably come to the conclusion that all of these are pretty serious offenses. I think the question is, what do we do with this list? You know, and kind of where do we go from here? And so if you look at it, if you know, I mean, if you look at it one way, you know, at the end of this process, we might have the same list of very serious crimes that we had when we started. If we look at it from a different perspective, so for example, if the maximum time a person could be held without a hearing before a judge was significantly reduced, then it becomes a lot easier to have a more comprehensive list. But if there's no movement on something like that, then you really would want to make an effort to filter this down to a list of the most serious of the serious crimes.
I tend to agree, and I think we're probably thinking along the same track. I look at the whole list and I see, you know, these are all very serious crimes that speak for themselves about someone being dangerous if they would do one of them. However, I also agree that they are innocent until proven guilty, so we have to make sure that if they are held, it's for a limited period of time. With that in mind, I had contemplated discussing with the committee setting a requirement on the courts to hold a hearing on a weekend, be it via Zoom, electronically, however, so that someone's not held more than 24 hours without having access to a judge to at least listen to their case. I know our sister state to the south, Massachusetts, they have something similar called the Jenkins rule. If someone's going to be held more than 24 hours, they have to run it by a judge on the weekend. It's a phone call or a Zoom call. That way the defendant has at least had a set of eyes on it besides the commissioner. And then he just makes a quick decision, yeah, hold him, and then they arraign him and deal with it on Monday. Or he says, nah, you know, that's kind of weak, let him go. So at least I feel like I agree with you that if we're going to keep a comprehensive list, then we need to make sure that people have access to someone besides just in the police station. Any further thoughts? Representative Pratt.
I agree with the chairman. Salt should be on the list.
Any other thoughts?
That's it.
I know that we have a representative here from the police today. Would you like to share your input on our thoughts on this?
Dan Conley from the Goffstown Police Department. Specifically, you're just asking about the second degree assault or the whole list of
If you wouldn't
crimes?
mind, just I'm sure you've had a chance to look at the list
have,
of crimes.
yes,
What are
yes.
your thoughts on the crimes we have listed? Is it comprehensive enough, or do you feel like some of them maybe not necessary?
I believe they're all necessary to be in there. If you look at the crimes there, they all are either violent felonies. They're the two that aren't felonies. It's domestic violence and stalking, and those are two very serious crimes with a high percentage for lethality, just due to the danger that these crimes pose to the victims of those crimes of domestic violence and stalking. And stalking, if it can be a felony. The misdemeanor, the majority of ones that you see prosecuted as a misdemeanor, and it's usually for violating a no contact order within a previous bail. So if you look into stalking, a majority of the charges for violating that no contact provision from bail under 597. So they're already out on bail and then they're being charged with stalking because they're contacting the victim that they're usually under for domestic violence, and that's just the district court part of it. In the other ones, you know, of course the sexual assaults and the kidnapping and trafficking, they're just we believe from the Chiefs Association and just my personal thing, I believe they all pose a huge danger to victim and the public.
Thank you. Can you tell us what, if any, experience you've had working with the bail commissioners on these crimes? Have you seen people being let go on these?
Just from I'll speak just on the domestic violence and stalking as misdemeanors. Yes, majority of times, more likely than not, they're getting the PR bail. Under domestic violence, if you are charged with domestic violence, they will get a quicker arraignment date than a say a regular non-DV simple assault. They'll be arraigned within usually the next available court date, but in some courts that could be a week or two just because there's no judge. You don't often see it's very rare to see someone held on a misdemeanor domestic violence or misdemeanor stalking. And when stalking is charged for violating a no contact provision within a bail, it's very similar to violation of protection order. In violation of protection order, there's no bail, but for stalking, they get bail. So in the majority of the time, they'll be PR.
Thank you. Does anyone have any questions for the captain? Representative Stone?
Thank you, Mr. Chairman. In your experience, when someone's released on PR bail for domestic misdemeanor, say a simple assault, how often do you see them violating the bail on those cases in your experience?
I don't have a number for you or percentage, but it's common because they have a relationship, and more often than not, they try to contact them somehow. So it's not like, I wouldn't say it's every single one. I wouldn't say it's every other one, but it's more common than not. You see it routinely.
Thank you.
Is it true that the most dangerous time for a victim of domestic violence is when they try to leave their abuser, and which usually starts with the first arrest like this?
Yes, domestic violence charges just they pose a huge danger to the victim because, speaking from my experience and working with victims, when the police are finally at the house making an arrest, it's not the first time that victim has experienced violence from their partner. By the time we get there, it's usually an ongoing thing, and the victim finally had enough to call. And I'm not a domestic violence expert. I'm not, I don't work for one of the organizations that deal specifically with victims. That's just from my experience.
Thank you. Is there anything you'd like to? Oh, excuse me. Go ahead.
Thank you, Mr. Chairman. You had mentioned when you go to a home, it's not the first time that this has happened. It's just escalated to this point. How many times do you have to go to a home when a concerned neighbor or somebody, just happens to be maybe going past that house and can hear, obviously something is not right, when the victim themselves is not able to call?
That happens a lot, especially in, we have apartment complexes. The neighbor will call because they can hear the damage being done in the house, or they see something or hear something. That happens oftentimes, and that is the victims. You often, when we show up, they're very nervous because someone else called, and they're nervous of what's going to happen now when we leave.
Representative Muse.
To what extent, when you take a look at it, sort of like the kind of like all of these cases, you've kind of put them all together. One of the things that I'm trying to work through in my own head are the percentage of people who, or let's say violators who are, um, let's say released after a domestic violence charge. So maybe a first timer or something like that, and and who go back and who are almost immediately in contact with their spouse again, or with whoever they committed the act of domestic violence again. So I guess my question is how common is it for somebody who's been charged to just go right back to the well and do it all over again?
Very common.
Very common.
And a lot of times the victims will not notify us that either the defendant has come home to where they are, or is contacting them in some sort of way. The majority of time, we end up, arresting them for violating the bail order or charging them with stalking. Is usually we see them with them, or we see them at the house, or we get called there again for another crime and he's there or she's there, and they have bail against being at that person's house or within contact with them. When they get on, we see it a lot of times, is when you start going for domestic calls, you end up going to that same address repeatedly because they're in a cycle of violence, and you're just going time after time after time, and it's the same people, it's the same victims, it's the same defendant.
Thank you.
Ken, do you, for the benefit of the members of the committee who don't have a lot of criminal law experience, could you tell us about the power of the police to charge, even if the victim doesn't want a case brought?
Yeah, we can, based on what the officers observe, if they observe injuries, they observe a red mark on the face, even if the victim is not going to, the police officers can kind of put some evidence together, but you can still go forward with a charge where the victim is unwilling to, testify against that defendant due to, mostly what the officer observes when he or she gets to that scene. If there is an injury, if there's marks, you can still make a charge, go forward and work without that victim's cooperation.
Thank you. Since I have you here, I'm going to ask you a few other questions regarding the bail in general. With regard to what we're discussing though right now, so bail commissioners will let people go on PR, in your experience, but that is also in keeping with the way the current statute's written, is it not?
Yes, we rarely see a cash bail unless it's by statute for violation of protection order. Excuse me, or it's very, very rare to see a cash bail. Very rare, even on these felonies, even on these violent felonies, first degree assault, second degree assault, barring some, exceptional situation, they're going to get PR bail.
And just so the committee understands, it's not the bail commissioner's fault. I mean, this is this is why we have to change the statute, right?
I agree, and I would actually like to, felony reckless conduct we see oftentimes with involving firearms, and they're not getting cash bail.
Could you describe that? What
know,
that would look like?
A felony reckless conduct, someone fires a firearm at a house, doesn't hit anyone, but they fired it recklessly and it went through someone's, it could go through your neighbor's, door. We just had one in Goffstown end of August that, we had, we still in active investigation, but a house was shot at.
You're not talking about, though, someone recklessly target shooting. You're talking about like a drive-by, or just
Yes.
someone,
Yeah.
maybe an idiot driving around shooting?
Yes. Yep.
Okay.
Yeah. No. And just firing. It happens, and it happens in Manchester all the time. And absent some, like I said, some exceptional circumstances, they're not going to be held on cash bail.
I think anyone who lives in New Hampshire can take a look at any number of street signs and see the holes. And we know that there's a little bit of reckless shooting going on. So the committee will take that that crime under advisement. With regard to, do you see the value in having a judge have to take a second look at these? In other words, lifting it from the bail commissioner and making it go to a judge?
I do, and a benefit of that is that the prosecutor will also get to go in front of the judge, and whether that person's held or not, they can recommend conditions of bail to the judge. Whereas, if someone's arrested at night, the bail commissioner comes in, the state, the prosecutor, they're not going to find out about this until, yeah, and if those conditions aren't correct, or there's conditions that they would like added in there, you're looking at a couple weeks before they're going to get a bail hearing, because that person's released on PR. So they're not going to have a bail hearing on that, exponentially. It's going to be some time. So you could go a couple weeks, you could go a month with, and if there's, I've seen it happen before where it's a DV arrest, but there was never checked off the box for no contact. And a lot of times we don't have a correct address. Where's that person staying now that they can't go back to where they were living with their partner? And that leads down the court's sending them notices, but they're sending it to the address where he's not at, and then you're racking up failure to appears because they're not. So there's a benefit of going in front of the judge, not just to hold someone, but to get the correct bail conditions and have the prosecutor have a chance to weigh in on the bail conditions with the judge.
Thank you. I'm going to have another question, but I want to kind of set the stage for the committee first. It's my understanding the way it works is the bail commissioner will set bail, and there will be conditions. But when he's finished or she's finished, they have to take a paper form, fold it up, put it in an envelope, put a stamp on it, and mail it to the court. So before the court even knows this person's out on bail, it could be a week before the document gets to the court, before the court has time to open the envelope and enter it into a system. So you've got people floating around for up to a week or more on bail with conditions that only he or she and the police that arrested them know exist. So that person goes to another town or even perhaps another county. Nobody knows about any of this. And this is why we're taking a look at this comprehensively instead of just saying, oh, these crimes can't be. What good does that do if nobody knows about it? So in your experience, Captain, how long does it take? And a follow-on question would be, do you have the ability to arrest based on your knowledge of bail conditions if you see someone violating it? For example, no going to a bar or whatever, and you see someone blatantly violating a condition of bail that you know about personally.
If you had that knowledge, it would either have to be firsthand knowledge that you saw that bail condition, you saw the bail paperwork. You bring up a good point, because if someone's arrested in Goffstown for domestic violence and they're given conditions of bail from the bail commissioner, and then they go to Manchester, they go that same night, the next morning, and they're in a restaurant with that person and the police come in contact with them, unless they know to call over to Goffstown to check, they're not going to know that that person has bail.
And does that apply to protective orders as well? I mean, if someone in your jurisdiction in Goffstown gets a protective order against their spouse and they get into a domestic altercation in Manchester, 3-4 days later, does the Manchester police even know that a protective order exists?
If it's in the system, and I can't speak for the court as to what the timeline is or when that is entered into the system. So I do know well, it wouldn't happen too much, but if we, Goffstown police will notify you know, if the person lives in Manchester, you know, we may zip like a fax over, but oftentimes I don't know how quick that gets in the system.
Well, what we know, let's just talk about let's not talk about orders issued in the court, because that should theoretically be in the system right away. But let's talk about emergency orders that are issued over a weekend or a holiday or a Friday night. Is there any way for another department, barring you faxing it around the state, for them to know that there's a protective order?
I'm unaware of that.
That's all I have. Representative Stone.
Thank you, Mr. Chairman. One of the questions I have is that your agency, when a bail commissioner comes in, do you provide them with a probable cause affidavit or support of arrest?
They will have when the bail commissioner is there, oftentimes the guy is arrested, he's brought in, he goes into booking, the bail commissioner will come and say, what are the charges? But there's no report done at that point. So we bring someone for domestic violence, they're brought in, they're arrested, they go into booking, the officer's there booking him or her, and they'll call the bail commissioner while he's doing his, you know, getting the fingerprints, going through the list of, you know, his background and name, and they'll run his criminal record. And we have a dispatch right in our police department. So dispatch will run that criminal record and give it to the officer. So the bail commissioner will really only have, and we're lucky enough to have a dispatch in our police department. So we have access to run a criminal record 24 hours, 7 days a week. There's police departments that don't have that luxury. So all the bail commissioner is going to see is the charges and his criminal history.
Follow up. In addition, is it typical for a bail commissioner or the officer to kind of give a quick rundown of the charges that are pending at that time he's having bail set?
Previous charges or
No, the current charges. When someone's arrested and they're in
Yes.
the booking area and the bail commissioner comes in, does typically the officer of your department that you may or may not be aware of kind of give a synopsis of what brought that person into custody?
Not all the time. If there's extenuating circumstances, they may, but they're really only, the bail commissioner is only seeing the charge in his history.
So they don't give them, for example, you have a domestic violence arrestee. The bail commissioner only sees domestic violence arrest. He doesn't say, you don't explain, okay, yeah, he actually, we saw him beating up his wife, or there's no background at all.
They
to the
they will
charge?
give a quick background, but they're not going to have a full out
Report, right.
Gerstein or probable cause affidavit. You know, they'll ask for, you know, what was the victim's name? Should be no contact, and those questions they'll ask, but they're not. The officer hasn't even sat at the computer yet and started typing until usually the bail commissioner has left and that defendant has been released.
And that's assuming the officer wasn't injured during the arrest. What do you do in a case where that happens? I mean,
That wouldn't, you know, if the officer is, you know, at the hospital, they're not, you go to, you know, cities, Nashua, Manchester, that officer that makes the arrest, you know, they may not even transport him back to the police department if they go in the wagon, or they bring him to the booking, they drop him off, and there's a booking officer then will take down, here's his charges. And then the bail commissioner will come in and speak to the booking officer who wasn't even at the scene.
and it can take a while for the officer to have an opportunity to write the report.
Right. It
If
could.
he has to go to hospital first, or
Right,
he
it
could
could-
still be at the scene.
Yeah. Yeah.
Okay, excellent. Hold on a second. I had a few other questions that this line is brought up. So we're contemplating, and we've just discussed possibly if we have this list of crimes and the person is non-bailable by a bail commissioner, and we were to require a judge to do a hearing on a weekend, do you have any other instances where you contact judicial system over the weekend?
We do, for, you know, emergency, protective orders. emergency, search warrants. Judges are available by phone for those emergency situations, emergency arrest warrants, search warrants, protective orders.
Would you give us just an example, just a kind of a rundown how that would work? Do you fax them? Do you guys Zoom? How do you do it?
So would call the on-call judge. We have a list. The county will give us of the judges that are on call, and they'll ask, for instance, say it's a felony domestic violence and we need an arrest warrant. And we can't, you're not going to wait till Monday because of the danger it poses to the victim. So the judge will, officer would call the judge, say, this is what we have here. Excuse me. He or she would say, can you either email, majority of the time it's email. They don't have fax machines at their house, but email or fax me your affidavit and warrant and stay on the phone. And the judge will read that, have any questions asked, and then, zip it back to the officer electronically. And now that they do have the court does have a new electronic system of signing those, but they will call the judge to bring it to their attention immediately.
Okay, so the court does have some experience with exchanging evidence with the officers and talking to them over the weekend.
Sure.
So adding very serious crimes that would require them to make a decision on bail wouldn't be that big of a stretch, or at least not totally alien to them.
I don't want to speak for them, but we do contact judges on nights and weekends.
Thank you. Back to, yeah, how often does that occur? Roughly? Once a week, a couple times a
I would say just for Goffstowns, yeah, maybe once a week, a few times a month. If you were to ask Chief Aldenberg in Manchester, I would say daily.
Okay. Something else you brought up that's interesting in the committee, I know it, but the committee, I think, needs to know it. There are police departments, and I want you to correct my statements, that in this state that cannot sit down and run someone they just arrested, they cannot run their criminal record. Is that accurate?
I have heard that. If they don't have a dispatch center, they don't have access to that. They're not going to be able to run a triple I or a criminal history.
And do you run a triple I for the committee as a federal check with the FBI that shows their record across the country? Do you run a triple I on every arrestee?
Yes.
Okay. And you run a New Hampshire record check as well?
Yes.
Okay. So there are departments, to the best of your knowledge, probably in more rural and northern sections of the state, that don't even have a computer terminal where they can sit down and check the record of the person they have in custody, meaning that they could potentially be a fugitive from justice from another state. There could be any number of things that the police just don't have access to. Is that accurate?
Yeah, if they have a dispatch center, outside dispatch center like a county and they're not, their dispatch center is probably running that for them, and then they're going to have to make their way at some point over there to pick it up. There are triple I's, you can't email them. There's very strict security measures with the records. So I would assume that would have to drive to that dispatch center, wherever it is, wherever it was printed, to get it. And that may not be that shift. That may not be that day. They may just make a trip once a week. I don't know. But I have heard that if they don't have a dispatch center, they're not running it in-house, and they're not going to have it on hand.
And if there are many police departments in the state that may only have one officer on at night, is that correct?
A lot.
So you've got one officer with somebody in custody. It's not really reasonable to assume he's going to be able to drive to a dispatch center that may be 20 miles away.
Now, Goffstown Police, our dispatch center also dispatches for New Boston Police, Ware Police, and Dunbarton Police. New Boston and Dunbarton often only have one officer on. I don't think, if they have two, it's during the day because the chief is there. When they make an arrest, our dispatch center runs their triple I. We may not see them. They may go to their own, they may do the booking at their place, not come, then we'll put it aside for them for when they come to pick it up.
Are you allowed to broadcast over the radio if there's the contents of the triple I to tell the officer this is what you got?
I don't know I don't know that. You don't hear it, but I don't know if that is breaches any security things with there. It might. I'm not sure.
Could you check on it
I
and
can
let
check
us know?
that up. Yep.
Also, what about out-of-state warrants? You know, you got your fugitive from justice warrants. You could have someone you pick up who's got a warrant out of Illinois. Is the dispatch center allowed to say that, to the best of your knowledge? Say this guy's got he's wanted from
Yes.
Illinois.
Yes, and that happens often.
Now, in that case, how do you handle fugitive from justices with regard to the bail commissioners in the bail system?
It depends if it's extraditable. Oftentimes they'll have a warrant that isn't in New England. It could be out of Texas, but it says only surrounding states. So we won't be able to take them into custody on that. If it's one that we can take them into custody, say it says, arrestable in New England states. That's often what you see. We'll take them into custody. We will hold them, contact the agency where their warrant is out of to see if they're going to come get them. Because that's a question the judge will ask. Is this agency going to come get them? Because I'm not going to hold them if they're not. So that's the way we go with that. When the agency says they're going to come up, the judge usually wants them within 7 days to come pick this defendant up.
So, for example, for the committee, you could have somebody with a warrant out of California for failure to pay a fine. Generally speaking, that state is not going to spend thousands of dollars for several officers to fly to New Hampshire to pick up someone who owes $100 fine. That's, I think, what you're trying
Right.
to.
No,
Yeah.
they're not going to. We'll see it a lot of time out of New York, and exactly, or a low level crime, and they're just like, we're not coming. If they get picked up in state, they'd hold them, but they're not going to come out of state to pick that person up.
Do you know if New Hampshire, as a state, do we have any policy on people that are running around our state with warrants out of other states? Do we anyway do anything about it, or we just let them?
Say I enter a warrant and I put it in an NCIC, that you have to check off, do you want this person arrested out of state? In how, you can check off nationwide, New England, or neighboring states. So if we have people running around New Hampshire with with warrants from out of state, we can only arrest them if it says that we're able to. So for instance, if it's California and it says neighboring states, we can run them. He could have a felony warrant out of California. We can't arrest him. But if it says, Massachusetts, they get a warrant out of Massachusetts and it says extraditable for neighboring states, we can arrest. It depends on the issuing agency, what they do with the warrant, that will dictate how we can take them into custody.
Many states, and correct me again if I'm wrong, have a system whereby if you have a warrant, at some point your driver's license gets attached and you lose they suspend it. If someone's license is suspended in California for a warrant or failure to pay a child support or something, we do recognize that, and their New Hampshire license would also be suspended. Is that your understanding?
Yes, there would be. You could arrest them for operating without a valid license, but unless that
Underlying
warrant
charge.
is extraditable, we can't arrest them for that.
Okay. Any other questions for the captain based on? I'm going to call him. Representative Sytek, did you want to ask a question or testify a little bit yourself? So, to add some more to the captain's testimony, if they picked up someone from Massachusetts, which said neighboring states, they wouldn't even have to call the bail commissioner because it's not bailable. If the charge says,
And that's when we go in front of the judge, and that's the questions the judge will ask.
Okay.
I was talking about.
Representative Reed.
Thank you for my question. So this did, nonviolent crimes are down, violent crimes are up. How long are the defendants being held? You know, during the week, they're probably in and out within 24 hours. But what's your experience with, you know, how long is an average hold for a person with a charge with a violent crime? Are they in and out? How long is
That's
the average
getting-
hold?
That's getting PR bail, or that's going in front of a
So,
judge.
so somebody gets arrested for carjacking with a weapon or whatever. That you get arrested, charged with a violent crime with a weapon, and it's a Friday. How long is that person held? Are they just?
Are you talking about they're not making bail? They're not getting PR bail. They're going to go in front of a judge.
So there's no way they can get bail. So if they don't
Okay,
go,
so if they got arrested Friday, they would be arraigned the next court date.
Monday. So is that common? I mean, do you see most people held greater than 24 hours, or are most people released within 24 hours? Is the 24-hour hold or greater commonplace?
They're usually released that next court date. So it would be less than 24 hours if they were arrested on a Thursday
Right.
night. But if they're arrested on a Friday, it could be Monday or Tuesday, depending on if it's a holiday. But they will get the next court date.
Right, right. Okay, thank you.
And just to, I think what the representative was asking is violent crimes that are, the decision is made either by the bail commissioner or by statute that they're not bailable over the weekend. How often do you see that? In other words, how often do you have to feed people over a whole weekend?
Yeah, that would be a great question for the county jails, because we won't hold them. We'll bring them to the county jail. But I can speak for Goffstown. We don't often have anyone that gets held. They're all usually PR bail. I would assume the city would have a lot more that are being held, but I don't know what the numbers are on that.
So it's really a demographic issue. Wherever you have more violent crime, you're more likely to have people held. At what time in the process that someone is being held do they get transferred to the county jail?
If they're being held, we'll have them at the county jail within an hour or two. They're only going to be at the Goffstown Police Department enough to get the booking procedure done, and then we're going to drive them over to Valley Street Jail in Manchester within, I'd say, an hour, maybe two max.
Thank you. And Representative Pratt.
You mentioned that they would be go to court the next court date. Are there holidays for the court?
The court does have holidays, yes.
So it might not be Monday.
No, it could be Tuesday if there's a Monday holiday.
Okay, that's it. Thank you.
Back to the technology, just real quick. And I'll ask you to put on your chiefs of police. I know that you're just kind of loosely representing him today, but do you see value in ensuring that every police department in the state has a connection to check records and
Yes.
wants and warrants?
Yes, it would be. It's really, really helpful to have a cross-agency check,
Yeah.
and that is not running a criminal record, but you could run. You know, we have an internal system, so if they're in Goffstown, we run them. We may see that they were just arrested last night, or we were just there for a domestic situation where there was an arrest, but I can see that there was a report from yesterday. Manchester won't see that because it's only in our system. Nashua State Police, they won't see that because it's only in our system. If there was a way to cross-agency check everything, that would be extremely helpful.
And if you know, just for the committee, correct me if I'm wrong, most of our surrounding states have this and have had it for decades. Is that not your understanding as well?
I can't speak to that.
Okay.
I don't know.
That's fine. Is there anything else you'd like the committee to know while you're here?
No.
Okay. Any further questions before we let them know? No. Thank you for your testimony this morning.
Thank you.
I just have a comment for you, Mr. Chair, if I could.
Yes, go ahead.
So I'm just wondering if before we make a firm decision on what in this list we include, if we could hear from the public defenders and victims first, just so we make it clear what the effects of a crime like stalking, even if it is a misdemeanor or something or the other, would be on somebody, whether they're being charged with it or if it's a victim of one of those crimes.
Yeah, that is my intent. I have invited the Domestic Violence Coalition and the Public Defender's Office to come in. It's my intent that we don't vote on anything firmly until we're just about finished. We're going to have informal votes, so we kind of don't have any surprises when we start putting this package together. I want to have every possible bit of knowledge that we can get before we make a final vote on anything.
I appreciate that.
But I think the committee, some of us may be shocked by the fact that where we are technology-wise in this state, we make a lot of assumptions based on what we watch on TV. And some of us sadly aren't shocked, but it's not that way. It should be, but it's not. You see on television someone getting picked up and they're in their car doing a quick boop, 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 and they know the guy's, credit history. Here, our officers are asked to, and our bail commissioners, frankly, to make decisions based on no information than other than what sits in front of them right then. And whether or not that's true, that's anyone's guess. They ask, are you out on bail? Well, maybe the guy will say yes, and maybe he won't. We heard before from the state police that they would often find out someone was on bail because when they were arrested and inventoried the car, they found bail slips in the car. So I don't think that's a way to run a criminal justice system. And I hope everyone agrees. Representative Gathright, please, by all means. Officer, would you mind taking the one more time for a moment? And I saw you, Professor Scheer. Would you mind? We just have one more question for you.
Thank you for taking my question. I just want to make sure that I truly understood what you said when you talked in terms of you have access to a judge under certain circumstances. Is that correct?
That's correct.
Okay. So if someone's arrested and the bail people, commissioners say, we're going to bail them, but you don't feel they should be bailed, you can call?
No.
Call judge?
No, we cannot call a judge for that.
Okay. So if it's a bail issue, you can't.
No.
But anything else you could?
Not anything else. It's really strictly for emergency situations
For
where
warrants?
search warrants, arrest warrants, emergency protection orders.
Okay. Thank you very much.
Along that just gave me an idea also. Would there be any value in giving the police the opportunity to appeal a bail commissioner's decision? If, say, on a Thursday, somebody was arrested, or no, make it a Friday. Someone's arrested, the bail commissioner says, I think I'm going to let him go. And based on your experience with this particular individual that the bail commissioner might not be aware of, or the background situation, you think, geez, I'm just not going to feel good tonight letting this guy go. Would there be any value in allowing you to appeal it to a judge?
There would be, because the only avenue that we would have at that point, the state would have, is the bail commissioner release them. Prosecutor, police don't, they have some circumstance they don't believe that. We'd have to file a motion to have a bail hearing. And that could be a week, it could be 2 weeks, it could be 3 weeks that it gets scheduled, because the priority isn't for non-incarcerated defendants. If he's not incarcerated, the court is not going to schedule that the next day. That's the only way they're going to schedule the next day, if he's incarcerated. So if he's not incarcerated, you're looking at weeks before you get in front of there to address your bail concerns. So he or she is out for a couple weeks. It could be 3. It could be almost a month at some points if there's no judge time, or that you're in a court that doesn't have a judge every day.
And that's kind of gambling, because either he's going to do something or he's not in that time period.
Right.
Okay.
Oftentimes when we see bail being violated, it's fairly close to the time that they're released. The time right after a domestic, a time that they're usually it's those days after it that we see that they're violating the contact.
Thank you. Any other questions? Okay, thank you. Professor Scheer?
Thank you. I'll be really brief. One, I was just talking to one of the bail commissioners. They don't put the court order in the bail order in the mail. What happens is once the bail order gets signed, they fax it to the court. So it's not as it's not as long a period between the time the bail order is issued by the bail commissioner and the time it gets to the court.
It's my understanding. I had heard that some bail commissioners don't have fax machines. So
Yeah, and maybe
I'll hear for some. I'll
Yeah.
hear from the bail commissioner.
the hard topic is domestic violence issue and bail, and I fully appreciate having known personally people who've been victims of domestic violence, about what I would call the scourge of domestic violence. As with addiction, and mental health issues, it's really dangerous to try and use the bail system, not the whole criminal legal system, but the bail system to sort out too much about domestic violence. The perfect example is this: whether whether you hold a person even on a misdemeanor domestic violence for up to 24 hours, or you hold them for 4 days. My understanding in talking to any number of people, they're not going to be any more cooled down when they get out of jail after that hold than they would be if they get out on PR bail. And that's easy for me to say. I think it's actually quite true, but I don't know what the answer is. But I just caution the committee in feeling they can address the issue of people who are charged with domestic violence, and once they get out, either immediately on PR bail or 24 hours later after seeing a judge, or 4 days later, that the likelihood of them violating a protective order or going back to where they were and becoming involved in negative ways with the victim, it's still pretty high. So I don't have a neat and tidy answer. The neat and tidy answer is one that we can't do. It's like we can't hold everybody who's charged with misdemeanor or felony domestic violence until they have a trial. I mean, that's not realistic. I don't. I wish I could offer the committee an answer, but I caution you about thinking that the bail system as it is, or making changes in the bail system, is going to deal in a realistic way with the substance of this problem. That's a depressing thing to say, but second to last. The difference between calling up a judge and getting a search warrant, or going to a judge's house, knocking on the door at 6 a.m. after alerting the judge, and getting the judge to sign a search warrant because you need it on the weekend, and having a bail hearing is, at a bail hearing, you're going to need to have counsel. And with all that comes with it, particularly if it's a bail hearing where you're looking to detain somebody without bail, you're going to have, it's a significant event that can't be done in the same way that getting a search warrant signed can be done. That said, yes, judges sometimes do weekend duty. I've talked to judges who, particularly in more busy areas, counties in the state, where they frequently are signing warrant. The police are coming to their house to get them to sign a warrant, or in so-called modern times, significantly after I finished practicing, they can do it electronically. But it's judges work on the weekends, but they haven't been doing things as significant as bail hearings.
A quick question before you go to your next. From a constitutional perspective, if someone's arrested and you have a bail commissioner making a decision in a non-adversarial type of situation. Why could a judge not do the same thing in replace? Assume we had no bail commissioners and only judges made that quick decision regarding bail. Why would you need to have a full hearing with a full panoply of all the actors and make it an adversarial versus where the commissioner does? Is it just by virtue of their office?
No, no. When you're seeing a judge about bail, the judge is setting bail for the entire time up to the trial occurring. So potentially somebody can be held if they're seeking to hold somebody without bail. The significance of how long somebody can be held, the significance of the extent of the deprivation of liberty is such that you're entitled to that array of due process rights, clear and convincing evidence standard, counsel, the right to call witnesses, to cross-examine. You know, that's constitutionally a case called U.S. versus Salerno has laid that down. When somebody is seeing a bail commissioner who has the power to detain somebody without bail, but even under the system as it is, it can't be any longer than, you know, right now the system can be as long as 4 days. That's a shorter period of time. The extent to which you get beyond 4 days, you start to run into constitutional problems. The extent to which the deprivation of liberty gets longer than that, constitutionally, you start to run into, let's call them Salerno problems. So a bail commissioner is only deciding to hold them until they see a judge. A judge is deciding to hold them until trial. There's a big difference between deprivation of liberty and those two.
Could we not craft a statute that said a judge on a weekend hearing can only decide, and this would be a dangerousness, flight risk hearing or decision, only until the next court business day, where they would be entitled to their full Salerno hearing?
To be a little too cute.
I don't want you to tell me if the court would like that or not. I just want to
No,
know.
no. I'm not going to say it. That's essentially what the system is now. Yeah, effectively.
Indeed, but we have a
The bail
jurist.
commissioner's doing it and holding them till they can get to court. Changing it to a judge to hold them until they get to court, 6 to 1, half dozen of the other. It's the same thing.
What was your next point?
Actually,
I'm sorry, I didn't see Representative Stone.
Thank you, Mr. Chair. I guess my question to you is, do you think it would be beneficial for more information to be available to a bail commissioner with the facts and circumstances of individual cases when it comes to weighing out public safety versus liberty?
you know, I think it depends on the jurisdiction. The chief you heard from is Goffstown. You know, I think it varies tremendously from police department to police department and bail commissioner and how much information they have. You know, sometimes the police are arresting somebody who they know, you know, and it's not unusual, and they have tons of information. You know, that's the case. I know that's very frequently the case in Portsmouth. Other times in the bigger police departments, they have easy access to more information. I don't, it's always good for anyone who's making a decision about depriving somebody of their liberty to have as much information, to make a decision whether to deprive someone of liberty and protect their public safety or not, to have as much information as possible. I think, as the chair has made clear, you know, I too am a very strong advocate of improving the communication and the access to information in the state, because I think that'll make a big difference for everybody.
Thank you.
Again, from a constitutional perspective, is there less of an issue with including domestic violence in a list of crimes like this? if we're only talking about 24 hours or less to see a judge versus more than 24 hours? Or are there other reasons why, from a constitutional perspective, it's a good idea to not include a crime like that in this list?
I think if somebody who is included on this list and therefore doesn't see a bail commissioner and they wait to see a judge, I think yes, I would have some different feelings about what's on the list. Now, as to domestic violence, I go back to what I said earlier. If you hold somebody for 24 hours who's charged with even a misdemeanor domestic violence, yeah, I just don't, in terms of them going back and causing trouble with their victim, I just don't think holding them for 24 hours is really going to change that. So domestic violence is it's just a difficult problem. And it's really hard to use it's even harder to use the bail system to make any progress in solving the problem with domestic violence crimes than it is with addiction or mental health. It's just a really hard problem. That said, a separate issue with including misdemeanors at all on this list is it means there's going to be a heck of a lot more hearings on Saturday and Sunday. And I think you've heard from the court system before on the list that was in Senator Soucy's bill and has been in Senator Bradley's bill in the past. That most comprehensive list would involve 3,000 to 4,000 more hearings than there would otherwise be because it has misdemeanors on it. So it's an odd thing to say, but putting aside the constitutional issues, there's a real court expense to having misdemeanors on that list rather than just having felonies. And it's a balancing, there's not a nice, simple answer. Just transition to the last thing I wanted to say is I'm an advocate for having felonious stalking, felonious domestic violence on the list. Because those are particularly serious domestic violence related crimes, not to suggest that other misdemeanor domestic violence isn't serious, but in terms of at least a 24-hour hold, if we have a system where they're going to see a judge in 24 hours, I think that's really important. So that's what I advocate. I understand there's differing views on that, but I think the committee is really beginning to understand there's not a neat and tidy answer to this, that it involves a balancing of court costs, it involves a balancing of constitutional rights, it involves a balancing of public safety, and that's why you all get the big bucks.
Although, when it comes to one of the things, an impression I get every time I hear testimony from bail commissioners is that there do seem to be a different set of personal standards that people use in making these decisions. So if we don't put something like misdemeanor domestic violence, on this list, then basically it would go back and be something where we would be really dependent on bail commissioners to make a really good decision. So with that in mind, should we do something like that? Do you think part of whatever we wind up proposing should include training, perhaps mandatory training for bail commissioners specifically in areas, things that may be on this list now that might not wind up being on the final list, or some of the things that we've actually already talked about, one crime that's not on the list that maybe should be.
I'm always an advocate of training, not only for bail commissioners but for judges. Mm-hmm. I will be very blunt with the committee on domestic violence crimes. I don't think judges make any better set of decisions as to bail on domestic violence crimes than bail commissioners do. You know, so I think it's training across the board. And I know the Superior District Courts have made aggressive efforts to do better training. Again, I hate to end on such a negative note. The problem of domestic violence in the criminal justice system is a big one, and it's really hard to manage. And the bail is just, there's not that much other than holding anyone charged with domestic violence until they see trial. There's no easy solution. And, you know, for the reasons I've described, it's just really hard problem. I hate to be so negative, but that's what I've seen over 40 years.
Thank you.
Thank you for your testimony, Professor. Hold on. We've heard quite a bit of testimony, and my intent is we're going to take probably a 15-minute bar break in a minute, and when I come back, we've heard a lot of testimony, and we've mostly been talking about bail commissioners, and right in front of their faces. So we're going to let them talk to us when we come back. I want to hear from the bail commissioners, all including Representative Sytek. If you'd like to add something real quick right now.
This would be very quick. I yearn to say many things, but let me stick to one fact. There was almost horror talked about because the papers are so long getting to the court. The bail commissioner's handbook written by the judicial branch gives bail commissioners 2 days to get the papers back to the court.
Thank
That's
you.
a fact.
Are you aware of how long it takes the court to get them entered into the system so that everyone else knows about them?
I have no idea, but I wholeheartedly support your idea of greater, and everybody's idea of greater communication. A bail in Manchester should be known throughout the state. But that's in a different, I'm talking beyond facts.
Representative, did you want to add something?
Yes, I did, Mr. Chairman. Thank you. So we came here last week and we heard a lot of testimony. We're sitting here again this morning and we're hearing a lot of testimony. And the one thing that I think that we as a committee need to understand is the victims of these crimes should never under any circumstances be blamed for being the victim of a crime. And I can appreciate the testimony we're hearing, but I also know that when you have a domestic violence victim, these human beings are either being beaten or they're just being degraded into submission. So maybe holding them for 24 hours doesn't give the perpetrator a cool down period, but what it does do, it gives that victim and those children a chance to get to a safe house. It gives them a chance to get some funds and get away. And I think that we need to get back to focus on the victims of these crimes, not protecting the perpetrator and finding an excuse.
I wholeheartily agree, except for a very small alleged perpetrator, and we always have to keep that in mind. Even though it hurts, I agree that that period of time does give the victims a chance to collect themselves and get some protection. But we always have to keep in mind it's alleged, as much as we know it maybe not be, in however we feel personally. But I wholeheartedly agree that a certain period of time isn't necessarily only for the defendant to cool down, but also, exactly to your point, for the victim to get themselves someplace safe and the help they need for their families and their children. With that being said, we're going to take a 15. Did you have, Representative Meese, did you need to add something? We're going to take a 15-minute break. So we'll be back here at 20. Let's just break until 20 till, at which time I'm going to ask the bail commissioners to address us and maybe take some questions. And then we'll end the day with some discussion on the committee about everything we've heard. Is everybody okay with that? Okay, we will be breaking for 15 minutes. And we are back. I apologize for the delay, but fortuitously, I ran into one of the finance chairmen because we have been talking about spending a lot of money in here. And he is going to come next Thursday, Representative Weiler, and we're going to pitch loosely some of the ideas we have. And he's going to tell us whether or not there's even money for it before we get too far down the street. And then we'll have him come back again when we have some more hard numbers for him. So I think that that's a good start as far as making sure we're not contemplating pie in the sky. I don't have any control over that. So at this point, I would really like to hear from the bail commissioners. I'll start with Mr. Lafarbe. You are no longer officially a bail commissioner, but you have more years doing it than most of us have on this committee or any other. So we'll start with you, and then we'll move down to whoever else would like to testify. For the record, I do not believe Representative Sytek will be testifying. He's more of a source for us to tap when we're in our discussions, and we will certainly be utilizing him. So with that, I give you the floor.
Thank you. My name is Trixie Lefebvre. I had been a bail commissioner for 14 years and resigned effective August 31st of this year. The committee is on the right track, and I really appreciate that. Some of the things that I heard this morning, though, that I just wanted to clarify from my experience. I can only speak to my experience, but there was mention that we possibly, as a bail commissioner, when we're meeting with a defendant, do not have access to their criminal history in the smaller departments, especially because they don't have a dispatcher. I do know that when I was working for the Derry Circuit Court, if I would respond to Sandown or Chester, the sheriff's department was responsible for getting the criminal history to the police department via fax, and then I would review it. Never should a bail commissioner, and I did not, but never should a bail commissioner process an individual without having the criminal history in front of them. It's absolutely important. On that same note, there is also information if there are restraining orders against this particular person that we're processing, which then takes me over to the criminal bail protective order. Those are sent up to New Hampshire State Police immediately. When I worked for Manchester, and it's in the bail commissioner's handbook that we must send it up to them immediately. That's faxed from the Manchester Police Department. So the state of New Hampshire, every law enforcement agency should be aware of that within a half hour of our booking and processing the individual, I should say, because it's in the system. With regard to what you're thinking with your charges that an individual would not see a bail commissioner, you speak of domestic violence. I'm not pitching one way or another what charges would not be seen by a bail commissioner and what would go to a judge. I just want this committee to understand that when a person has been charged with domestic violence, you have a victim. If they do not see a bail commissioner, or if they are not processed immediately but taken to a county jail and held, whether it's for 24 hours or 48 hours, there is no order of protection for that victim, so that that alleged perpetrator could reach out to that victim from jail to continue with acts of intimidation, could call a friend to have acts of intimidation. So when this committee makes that decision, please be aware that there should be an order of protection for that victim immediately when the decision is made, whether this defendant is going to go to jail or be seen by a bail commissioner.
May I just interrupt? I don't want to interrupt, but I have to. I need to know. So is it possible, though, for example, say the police arrest someone on domestic violence charge, and it's one that in the contemplated would not be bailable by a bail commissioner, can they not call the judge to get an emergency order?
They can call for an emergency order, but the emergency order is, I'm not part of that process with an emergency order. I hadn't been, I should say. I am assuming that the answer to that is yes. But the alleged perpetrator is not being charged with is not being processed for the crimes. So the bail order, or the bail process would take place days later. So I guess there, you would need to seek clarification on that.
So there's two tracks. There's the bail conditions,
Yes.
which would set no contact with the victim, et cetera, which you are saying if we didn't have a bail commissioner and they get sent to Valley Street, they could contact because there's no bail conditions. On the alternative, though, the judge, an emergency order could be issued, as far as you know, that would do the same thing. It just would require the judge.
Correct.
And that would mean possibly for the committee 2 calls to a judge, one for the emergency order, and then within 24 hours, another for the, whether or not to hold or let them go.
For the actual arraignment. right.
Okay, please continue where you were,
Yes.
and I apologize.
Thank you. And my final note is, as you are joining other members of this process, of the process of defendants, is, processing defendants. There are times when these individuals are on probation or parole, and that you should be able to pick up in the criminal order that you're looking at, their criminal history. I have to tell you that in my 14 years of trying to contact a probation or parole officer to determine if they want a 72-hour hold, probably 1% of the time. And it could be a Friday afternoon, and I have someone in front of me and trying to reach their parole officer or their probation officer to determine what they want to do is darn near impossible. So I think that as you look at all of this as well, you need to pull into the grand scheme of things. The probation or parole should be as accessible as the judges are after hours.
Thank you. Actually, I was contemplating this. I know that in Massachusetts, and I hate to use them as an example, but some things they have right. If someone, even if a police department even runs a record check on one of their parolees, the system automatically pings that parole officer and says, someone's run your guy, at which point it triggers him to call the police and say, why'd you run my guy? If he's violating his parole at that point. So I think you're absolutely on the mark. We need to make sure we tie in all these. And even if it's only an electronic notification that their person has been held, they get it on the weekend, and whatever time of night it is, they get notified. Because I know parole officers, I believe, are, technically 24 hours a day. They're supposed to be on the job, so to speak.
That is what we are told.
So
We have never seen that as a practice,
yeah,
but that is what we are told.
Indeed. Representative, go ahead.
Thank you, Mr. Chairman. Thank you for taking my question. I would like to clarify something. We had heard that bail commissioners have, is it 48 hours, I believe, to get the bail order to the court? And we're talking about having an electronic system. We're kind of stuck in the 70s, 80s over here in New Hampshire. So would it be helpful, or did the bail commissioners have access to, I know I used to use online, it was called DocuSign. And the legal documents were already uploaded into that. You kind of filled it out and sent it to the person, and it kind of walks them right through. So would that be helpful if the bail commissioners had access to something like that, and then they literally could just hit the submit button and it go right to the court instead of having to wait for it to kind of wander around in snail mail?
I'm sure that would be very helpful. But I do know that when we were, just as an aside, as when we were talking during COVID of doing telephonic bails, there were areas of the North Country, especially over in the Ossipee area, that they did not have good service, good internet service. So that was a consideration. And then you also then are requiring every bail commissioner to have access to a fax machine, or even if it's a scanner, to scan an email. So that would be something that every bail commissioner would have to consider when they were taking their appointment.
And which raises,
It would automatically be in the system. They would just hit the button. They would
Right.
have access to the internet.
if they had a button. Which brings, is that, who's ringing? Is it Matt? Okay. I have this brings up, what kind of equipment are you issued? Are you issued anything, or?
Oh, no, we're not issued anything. No. Our equipment is pen and paper.
So if every bail commissioner were issued a laptop with a cell card, would that not, and access to criminal records themselves, would that not make sense? Or?
Well, may I answer something? I'd like to go to a first subject
However
and
you
then
like.
answer your question. During COVID, we were told telebails, so we could do those. During my period of time with Manchester Police Department, in order to, I did try to do some telephonic bailing through them. I was told that I could not get a criminal history because it was coming to a personal email and it has to go to a .gov. I brought this subject up to the Administrative Office of the Courts on 3 separate occasions, and I have still not received a response from them. So that being said, a desktop, I'm sure, but you may possibly, if we can't get an answer from judiciary in terms of if a personal email can get a criminal background, then you may have to issue .gov addresses to all of your bail commissioners to bypass that problem if you want to get into telebailing.
Well, that more importantly, I think what I'm contemplating is why would a bail commissioner who has by law the right to see criminal record information not have direct access to criminal offender record information? So if you got a call, you got to come bail Joe Smith, and you, before you even got there, could call up Joe Smith's record and know, this is what it doesn't make any sense that you are allowed to have it, but you can't have it unless I show it to you. It doesn't.
Right,
It
yes.
seems we're hamstringing our own system.
Yeah.
Any questions for Ms. LaFave? Is there anything else you wanted to add?
No, I think I've covered what I needed to cover. So thank you very much.
I appreciate it. Thank you. And next, I don't know your name, so I'm just going to say Madam Bail Commissioner until you tell us who you are.
My name's Judy Cook. I bail out of Milford District Court. I've been a bail commissioner since 1998, and I have gone through more iterations of being a bail commissioner than probably anyone else that's still a bail commissioner. What?
And by that, you mean the laws have changed so many times.
Exactly. Couple things. I have a suggestion to make to your committee. There is a website called New Hampshire Judicial Branch, and then Bail Commissioner Forms. And I think you would understand this process a lot better if you went on that website and downloaded the major forms that we use, which are the Circuit and Superior Court bail orders, the CPBO, which is the Criminal Bail Protective Order, the What You Need to Know form, the Request for an Attorney form. Those, and there's also the bond form. Those are the ones that we use. There's a few others in there that are kind of obsolete at this point, because you will then understand what we fill out and what information we have to get to fill these forms out. I've been doing telephonic bails since the beginning of COVID, and it became very clear to me that the police departments had no idea of what information the bail commissioners needed. So I developed this little 2-page form that when they email me, well, first they call me and wake me up at like 3 in the morning. And then I ask them to email me, give them my email address with their arrest form. So when I get that, I send them a copy of this with the note, any information that is not contained on your arrest form, please fill it out or just put it in an email. Very simple. I said the most important thing is if it's district court, I need your court date, because I don't have court dates for the whole state of New Hampshire. I do for superior courts, but not district courts. So that's kind of number one. I think you will understand a lot more. And once you read over, because you seem to be focused in right now on domestic violence, once you look at the Criminal Bail Protective Order, you will perhaps understand better how the whole system works. We fill out, there's like a heading, which is filled out by the court. There's the whole rest of the form, which is a 4-page form that we fill out. Now, if I'm doing it telephonically, all these forms are available in PDF fillable forms. So I will just sit down and I will fill them out as I go. Even if I'm at the police station sometimes and nobody's using the computer, I'll do it that way because they can read the forms better than trying to read my handwriting at 3 a.m. Okay? The only other question or answer I would like to give you on the domestic violence issue is I'm really not sure how much more a judge is going to be able to do with the perpetrator of domestic violence than I can do. Because A, it's going to be a longer period of time, as Trixie said. And B, when I see, and I see domestic violence all the time in my work as a bail commissioner, I make absolutely sure that they understand that if they transgress any of the things, and I read every single bit of each form to them because half the time alcohol plays a big role, and I'm really not sure that they're going to be able to read this. And I stress the points about no communication and all the different ways they are not going to communicate. And then at the end, I tell them, if you find it necessary to go back to that residence because your car is there or your clothing is there or your dog is there, whatever, you ask the police officer to accompany you, and that is the only time that you are going to go back to that residence until you are seen in court and the court trial, whatever, is finished. And I don't know that too many of mine have transgressed that. I've never heard back from the court that, you know, and I kind of keep an eye on my court, especially the one that's my home court. But, you know, I mean, I had one in Hudson one time when I was bailing over there, and it was this kid, and his girlfriend told him bye-bye, and so he threw her into the bathroom and nailed the door shut. Okay? So she's yelling out the window, the police come, they release her, they bring him to be bailed. At that point in time, it was bail reform and no cash bail, because we were actually told that about 5 or 6 years ago when that started. Okay? So I couldn't give him a cash bail, and I wasn't going to detain him. So I gave him the paperwork. I PR'd him, gave him the paperwork. He went right out the door, depositing my paperwork in the circular file on his way out, went back to the apartment, grabbed her again because she hadn't left, and tried to do the same thing again. Now the police were on to him. They followed him back there. He didn't even get so far as to enter the apartment, and they arrested him again for, I guess, stalking was the crime that time. And so I asked him, I said, why did you throw the paperwork in the trash as you were leaving the police station? He said, oh, well, I wasn't going to go to court anyway. I mean, you can't tell me what to do. You're never going to be, a judge isn't going to be able to tell that person anything. You know, I don't really see the difference between what bail commissioners do now and what judges do, except that we do it quicker because we're 24/7, 365. And if you rely on court times from 8 a.m. to 4, what are you going to do with all the rest of that? I have 2 towns in Milford District Court area that when I go to bail people there is a bench in the chief's office. There is a radiator with a steam pipe, and the defendant is shackled to the steam pipe. And, you know, I have to bail him that way. They usually do it with his non-dominant hand so he can sign the paperwork. but I mean, they're lucky they have a computer in that police station. And if you look at the sort of kinds of towns New Hampshire has, especially up north, you're lucky to have a room for the police station, much less cells, holding cells, booking areas. I mean, those are things that medium sized towns sometimes don't even have. You know, my town, I live in Brookline, and my town only got a police station probably maybe 15 years ago. And it's been revised since then. But I think, you know, you have to understand what we do, because I think only Mr. Sidek really knows what we do. These aren't those papers.
Oh, but might be helpful for us to see what you made
Okay,
if you want to share it. You don't have to.
No, it's fine. I'll bring it up when I'm
You can just
finished.
hand it to Mr. Sidek. Representative
You know,
Sidek.
I keep good track of my bails, who I bail, whether I'm paid, what courts they go to. And right now, I do a lot of telephonic bails because I'm willing to do that. And I'm running less than 50% on fees collected because of the telephonic bails. I don't want to take Square or any of those other electronic means of getting cash from people, because all they have to do is they walk out the door and they can cancel that. So I would rather, and we were told probably before COVID, Judge King sort of told us that we would, if we noted on our bail paperwork that we weren't paid, that the courts would try to collect that for us. And they've been very good about doing that. But I have to make a big asterisk on the part, because they've put another little line there that says bail fee $40, paid, unpaid, other arrangements. And then I write in there, you know, pay at court. And I've been collecting because of doing that. But Milford District Court has always done that. They've always been very good about collecting. But out of my 22 Superior Court bails I've done this year, only one has paid, which I find very disappointing.
You said you were less than 50% total. Is that
Total.
so? Milford Court's good, but some of the others not so much. I'm talking about
Right.
circuit court level.
Right. Portsmouth has been pretty good. Manchester's starting to get good. Dover, I've had money from them. But other than the Milford District Court, and I usually don't do Goffstown or Merrimack, which are in that circuit, because they have bail commissioners. Right now, I'm 77 years old, and it's me and Dick Lefebvre, who's 90, and we are the two bail commissioners in Milford District Court. And Dick can't drive at night, so guess who? You know, but it's not only that, it's very unattractive to try to recruit people to be bail commissioners when they find out you get paid about 50% of the time. And you have a limited supply of people, because people with full-time jobs aren't going to want to do this because they don't want to be up all night and they have a job during the day. So you're going to have retirees, people that are self-employed, that have the kind of self-employed jobs that they can run off and be a fireman or a whatever. You know, it's a volunteer job, sort of, just like your jobs. But our jobs involve a lot more travel. You know, I spent one whole day, I did a good thing, and you know how good things are, they always come back to bite you. I got 2 calls from Manchester one night around 3 in the morning that they had an arrestee that had cash bail on an electronic bench warrant, and they couldn't find a bail commissioner, and they needed a bail commissioner to go pick up that money. Okay? So finally, the second time they called, I said, all right, I will drive up to Manchester and I will bail this guy. I get up there. He has 3 cash bails out of North Hillsborough, out of Merrimack, which is Concord, and one out of, it was supposed, on the electronic bench warrant we get, which are very hard to read to begin with, it said it was out of Auburn. So there's no Auburn District Court now. It's Candia. Okay? So I go to Candia, and the woman there, the clerk, she says, oh, well, we're only doing civil cases now. You'll have to go to Derry. So I truck myself down to Derry, and they don't want to take the money because it says Auburn, which is now Candia. And I said, but the clerk in Candia told me to give it to you. And so finally she took the money. But, you know, it's like that was a whole day. My whole Monday was totally shot trying to get rid of $1,200 worth of, there were 2 500s and a 200. You know, I mean, it's not like we're having fun. And I don't know any bail commissioner that hasn't been trained. I mean, we get trained once a year at court. That's kind of like a catch-up. They now require people to shadow another bail commissioner for a certain amount of time. When I started this, I was just sort of handed my predecessor's bail bag with some forms in it and a few of their bail forms that they'd filled out and said, do it, you know, and I had to kind of self-train myself by talking to the police departments and talking to the court. So, you know, you guys are the ones that are making the rules. We're the ones that are following them, and I don't know anybody that's not following them. And not only because of, I fax everything, and not only do I fax it because I'm never sure of the fax, okay? I stick it in the mail too, so they're going to get 2 copies of everything that I do. So, you know, I don't know how much better we could be doing it. On the criminal bail protective order, Karen Gorman from Superior Court, she did a whole training session in each of the Superior Courts for those catchment areas around them, all about that. So I just don't know what more can be done.
If I could,
Yeah.
I know in previous legislatures, the bail commissioners have come under attack, and I feel like a little bit of your testimony is defensive, and it needn't be, because I don't believe anyone in this committee blames bail commissioners for what's going on here. You are doing what we told you to do. We just don't think what we told you to do was the right the right way to do it. So we want your input so that this time it's done right and we understand. So I appreciate you pointing us to those forms, and we make your job easier and not harder. At the same time as we take into account the whole system globally, because it's not just bail commissioners. To your point, it's the courts, it's probation, it's parole, it's police. We're dealing with it's defense counsel. We're dealing, and also very importantly, it's the defendant and victims. So there's so many aspects to this, which is why this time we decided we were going to look at it holistically instead of trying to patch all these little leaks. We're going to fix it, and so I appreciate it. I just don't want you to feel, or any other bail commissioner, to feel like this committee feels like any of this is the bail commissioner's fault at all.
I just want to leave you with one thought, that I've come to this conclusion over years of doing this. And it happened when bail reform first started to come into New Hampshire. And I thought to myself, because I'm a child of my father being in the military and moving every 2 years. So I've lived everywhere in this country. And the South is not noted for its fairness, shall we say, in judicial kinds of things. The North has been a lot more kind, I think, over the years. But I think New Hampshire, when they brought in the bail reform, they were fixing a problem that we didn't have. We might have had one or two examples of the problem, but it wasn't a widespread thing that was polluting our state. And all it did was create a problem that we didn't have. And I really don't want your committee to be creating problems that we don't have and solving them with things that only become problems. Because I think an example of that was Felony First, which they are now getting rid of in January. That was a problem that didn't need fixing. And it got fixed in a way that it only caused more confusion. And now they're going to throw it out. You know? So I just think hard about what you're doing, because the ramifications of it are any change, little change that gets made is a ramification that can grow into a big problem.
And I appreciate that, and I think every member of this committee does as well. We understand that the ripples in that pond. I believe we have a question before you.
Just really quickly, I don't have a question, just a comment for you, Ms. Cook. I just wanted to say thank you for your testimony and your experience and your wisdom in bringing it before our committee. I really appreciate you and your time that you have spent being a bail commissioner here in our state. It's a volunteer role, more so than what we do here. I mean, all we do here is sit at a table and ask questions. You're on the ground actually doing the work, and I really appreciate you doing that. So I just wanted to say thank you.
But don't forget, you might be volunteers that are sitting at the table asking questions, but the outcome of what you do is what affects everybody in this state, because it will somehow become a rule or an RSA or a something that is going to cause a trickle-down effect, and it'll land in my lap.
And we appreciate that. Thank you very much for your testimony. Yes. Go ahead.
Thank you for taking my question. You touched on something that I wanted to ask and clarify. Is there any direction given by either judicial branch or by the district court that you work for involving parameters of which you set bail on somebody who is intoxicated with either drugs or alcohol?
Like what we do with them, how we bail them?
Like if somebody's picked up and they're determined to be, say, DWI, and it's say, a Class A misdemeanor, is there a level of intoxication that you will not set bail on and they need to go sober up before you'll set bail, or do you just set bail right out of the gate?
Well, I have to set bail. That's why I've been called to the police department. But usually on arrests like that, the police department has already made sure that whoever's coming to pick them up, isn't intoxicated themselves, has a valid license. So when I set the bail for that person, they're given a time under the other section as to when they're able to drive again. And depending on how intoxicated they are and because I always ask the police department, because they see these people a lot more than I do, what their recommendation is. And it's either 12 hours or 24 hours before they're allowed to drive again. Now, they might get out there, they might go home, they might take their wife's car and drive again the next 2 hours later. Nobody can control that. They'll just get picked up again if they're weaving. And then if they get arrested the second time, it's much more serious. But if you see the forms that I'm talking about, you will see that there's all kinds of conditions, and there's always no excessive use of alcohol, no use of narcotic drugs or controlled substances. I always check those off, and I always give them a time limit as to when they can drive again. And that's what I could do. That's what a judge could do. There's really nothing more you can do unless and a DWI offense, especially if it's like a first offense, I'm not going to be sending him to jail for 12 hours. That would, I think, be frowned upon by the court, and that no judge would do that. Is that what you are thinking?
Yes, that answers my question. Thank you.
Yeah, because our jails aren't that big. We can't hold that many people.
Thank you. Representative Stone, if you could just, in New Hampshire, we have a protective custody statute that allows the police to hold them until they're sober and safe. Is that not the case?
I was just curious to see if we have a policy or a directive that if someone's intoxicated or incapacitated by drugs, are they actually understanding what they're doing at the time they're bailed? And if they take their conditions and throw them in the circular file, and later on, are they going to claim that they didn't know what they were doing and had no knowledge of it? I guess that's an issue some other states have faced. And sometimes I know, at least in the state of Vermont, they end up not setting bail until the individual is coherent.
Unable to understand their conditions. Representative Muse.
One of the things that we've heard several times from bail commissioners is the claim that the current statute ties their hands. So I've heard a number of folks who testified say that, I must do a PR bail in this situation. As I read the statute, though, it seems like a person can be held if it's felt that the court feels that there's a danger to the safety of the public if this person is released. So, I've got kind of a conflict. I keep hearing on the one hand that folks don't have discretion to hold people. On the other hand, I see in the statute that they do. And what I'm curious about is what's the filter that causes you to exercise that level of discretion in some cases, but not in others? And I'm thinking that, nailing the door shut with a woman in the bathroom and shoving her in there, that seems to be a case where you might want to exercise the discretion to hold a person over to see a judge rather than just PR bailing them. And it looks like the statute gives you the ability to do that. And so why not?
Yes, and especially if you have direction from the court not to, because that's who you answer to. So if we could hear that.
That would not happen now because they have added a section. That's why I want you to look at the forms, because there's now a section where if you want to hold someone in jail, I can now do that. But I have to kind of hold a hearing with myself and then write in my reasons for holding them. Because everything kind of defaults to release. And if you want to hold or do something other than do a PR release, you kind of have to do a wordy explanation of why. And I do hold people, but there was a period of time when bail reform came in that we were specifically told that PR bail was $0 and there would be no cash bail. And that unless something were really drastic, they weren't to be sent up to Valley Street or wherever the county court is. But that changed again. It's fluid. Things have been, I think COVID had a big effect on that because we couldn't go into police stations for a while and the court was closed for months. It was like a scramble, and now we're kind of coming out of that, and the rules change every year. When I go to a bail commissioners meeting, which there's one coming up in October, we hear about something new. I remember Judge Derby saying to us at one of the meetings, if somebody has transgress the same thing, like if they've been arrested for whatever it is 3 times in a row within 5 years, go directly to jail and wait to be bailed by the judge.
Actually, I think what you're referring to is if someone has failed to appear.
No, he was beyond that. It was if, well, it was, he had said, yeah, yeah. Or assaults. I mean, like domestic violence assaults.
What's interesting is I don't believe the statute has changed since 2018, but your instructions from the court seem to be what is fluid, and that seems to change.
The other thing is 2 years ago, when I started doing telephonic bails for Dover and Rochester, I had already gone to my once a year October bail commissioners meeting in Merrimack, because that's in our circuit. And then I got an invitation to go to the one in Dover. So I responded and said that, yes, I will go. So I went, and it was just very enlightening to me, the different ways that the different courts actually perceive what we are supposed to be doing. And for instance, one thing that stuck out in my head is there's a line, and this goes back to bail commissioner fees, but it says bail commissioner fee $40, and then it has a box to check off, paid, unpaid, and then there's a couple other things. So I brought this up to the judge in Dover because I hadn't ever been paid for any of my telephonic ones out of Dover or Rochester, which is her kind of circuit. And she said, "Oh, I never noticed that." And I said, "Oh, that's surprising because it's right next to where you have to sign off on the paperwork." It's like, so now I make a great big asterisk the size of a quarter, and I write pay fee at court in handwriting. And now I start to get paid. But it's like, aren't they supposed to read this paperwork?
If I may ask, how do you get paid from the court? Do they send you a check from the
Right.
state of New Hampshire? How does that work?
If the court collects the fee, then they remit it to New Hampshire Judicial Branch Administrative whatever. And that all gets aggregated, and I get a check. And sometimes it's interesting because sometimes I'll get a check for $40, or sometimes I'll get 2 of them on the same check. Sometimes I'll get 2 checks in the same envelope. I mean, and the other thing, you talk about communication, all right? I recently changed my post office box. And I advised the administrative court, and I asked Vicki Day, I said, "Who should I tell at Superior Court?" And she said, "You're going to have to tell every court you do business with what your change of address is." And I said, "Well, why?" I said, "The checks all come out of one place." She said, "Because when they do the paperwork and they send the money in, your $40 has to be directed by them to go to a specific address.
So the
And they never get rid of the old address."
So the finance people who cut the check don't maintain your information. They just
No,
each individual.
It's crazy.
Yeah.
I mean, this whole system needs an organizational person more than a rules person.
Yeah. Yeah. Well, sometimes the rule will make an organizational person appear. Thank you. Any further questions? This witness has got up several times. All right. Thank you. And next, thank you very much. Now I'm going to ask you to start because I believe you and I had a discussion is where I got this concept of having to mail some paperwork in. So if you could begin with that, I'd appreciate it. It might help my reputation a little.
Good afternoon, Mr. Chairman and members of the committee. Thank you for allowing me the opportunity. My name is Paul Leary. I live in Franklin, New Hampshire. I'm appointed as a bail commissioner out of the Franklin Circuit Court, which at the time was the Franklin District Court, which was only this much room rather than this much room currently when we have to write the checks. But that's a story for another day. One of the things that I keep hearing is people forget bail commissioners are directed to do two things in the paperwork that we hand out. I'm supposed to reasonably assure that the defendant will appear in court, and then by clear and convincing evidence that he won't reoffend. If he's going to be in that reoffending mode, that's when we check off preventative detention, and they go down to the jail and they see the judge within 24 to 48 hours, depending if it's district or superior court. At least in the circuit court bail order forms, we have room to write my reasonings down so the judge would see why I did what I did. In the superior court, it's just a checkbox, and the county attorney's office takes that over. So the thing is, I've been almost 35 years in law enforcement and public safety, and I'm 7.5 years as a bail commissioner, so about 43.5 years of playing the game. And I have a lot of repeat customers. I'm seeing children, grandchildren, and great-grandchildren of people that I dealt with out on the street. And I'm now working with children and grandchildren of police officers that I worked for when I was out there. So I've been around, I've seen a lot. And the biggest thing that happened, and Judy kind of alluded to it, was in 2018 when we had the big bail reform. Everyone slammed the brakes on and everyone was afraid to do something. I'm old school because I spent the time in law enforcement. When you got a question, where do you go? Back to the rules. You know, go look at the reason why the legislature did what they did. What does the RSA say? How did it affect? And then we also had to follow what the court was giving us for direction. And it was correct that all we had was PR bail. Before, it used to be PR bail and there was room for an amount. There was a period at the end of PR bail. They didn't want a number amount on it because before we do PR bail and we'd set an amount just to let them know that if it ever ended up as a cash situation, that's what it could be. And the days of the $25,000 and $50,000 cash bails disappeared. And we started seeing people that I was bailing out for $25, $50, $100. And if it was civil, $121.23. And you try to find pennies, nickels and dimes. Since I was a paper boy back about 60 years ago, I haven't carried that little change thing on my belt. So, I mean, there's a lot of things that are out there that go into it. But I think some of the things that I've heard, a lot of them are communication. It's like I heard talk about probation and parole. Well, because I was a police officer, I understand if I couldn't get a hold of the probation and parole officer, I would call prison control. And I would leave a message with prison control to let the PO or the parole officer know that they was requesting a 72-hour hold from the bail commissioner. And it would be done. And I usually will tell the police departments if we want to hold them on a 72-hour hold to reach out to prison control and make that phone call and leave the message. Once it's done, we can check the box off. So we've had some, luck with doing things like that. A few things that I've heard here about mailing stuff, faxing stuff, and snail mail. Snail mail, when I used to be able to send a letter out of Franklin, and in a day I could get it into Laconia, Concord, or Manchester without a problem. It's now 4 to 6 days to get it to them, so we have to keep that in mind. In other words, when I do the bail paperwork, I take the bail paperwork, fold it up, put it in an envelope that I have to buy, on paper that I had to buy, with ink that I had to pay for to make the form to send it out, and then put the stamp on it, and the stamp keeps getting more and more expensive, and then that goes to the court. Now, that's for almost everything. However, if I have someone that I'm holding overnight, I email to the courts. Now, the problem is for all the superior courts, we have a direct one from bails in the name of the court, and we send it to them. So they have it. So first thing in the morning when they get in there, it's there. With the circuit court, they do everything by fax. Well, I haven't had an analog phone line in my house in over 10 years, so I'm not paying $40 to $80 a month to have a service so I can send a fax to the court. Because again, I only get paid 62 to 68% of the time, but I do take credit card for bail and pay the $1.49. I looked at it this way, $38.51 was better than no cents at all. So, you know, it's one of those things that you just start balancing.
If I may just pause for a sec. So we heard some people say that, well, no, it's not mailed, it's faxed. That's not mandatory. So if you don't have a fax,
No, that's why I email. In
okay.
other words, you learn how to get around what has to be done to make it happen. And if not, sometimes what I'll do is I'll have the police department fax the form for me to the court to make sure that it's there. When it's domestic violence, it's pretty much spelled out. I'm required to send to the court that, and I send the ones that I know by email, the others I have the police department. If it's on Friday night until Monday morning or Tuesday morning, if it's a holiday at 8 a.m., the police departments are supposed to fax that information to state police, and state police will automatically put it into the National Registry on Domestic Violence. And that's one of the first things that shows up on the criminal records that we have an opportunity to see. Part of the things that you're talking about having access, there's a thing called CJIS. It's the federal regulations that say we're not sworn officers of the, in law enforcement, so we're not entitled to it. However, there is an exception in CJIS. As a bail commissioner, I can review, but I can't keep. They give me it, I read it, take my notes, I give it back, or they read it to me over the phone so I can have the information I need. So the thing is, that's happening. But where it gets problematic is right now I'm bailing in 9 counties because of COVID. I've done over 1,000 of the remote or telebailings. And you finally work around them and you make it work. Some of them we do FaceTime, some of them we do Zoom, but some of them don't have the connectivity, so we do it over the telephone. In other words, there is a way to make it work. But it becomes a challenge. The smaller police departments don't have access directly to any of that. If they go through a larger police department or a county, because of CJIS requirements, they can't fax it to them, they can't email it to them. They can read it to them, but the problem is if there's only one dispatcher on, they don't have the time to be able to do that. So that becomes a catch-22. And so sometimes the quick way to skirt it is because about roughly 95% of the people, when you ask them straightly, are you a convicted felon? Yeah. You on probation or parole? Yeah. And they'll answer. And, when you're going like it, that pretty much you got a pretty good idea when you start checking off conditions that you're going to want. And the thing is, it's nice to have your hand on the criminal record, but the thing is, sometimes it's just not available. So you figure out other ways to do it.
If the statute changed that you did have to swear, not for in whatever capacity, you would then be able to, in your understanding, access CJIS?
The CJIS has to do with federal. That's all the
Right.
federal agencies that state police signs off, and then the police departments sign off to be able to
Right.
get
But
that.
parole
you're
and
on the
probation
system.
officers have access to it, correct?
I'm not sure.
Yeah, I believe they are. So if we were to make sure that the statute provided you with the necessary access or necessary to fulfill the federal requirement for you to access it, I guess I'm getting at is, would it be better if you could just have those, see it in real time? Because I know if you got an arrestee from, say, Mass, because that's one of our closest states with the most population, you could have someone with a 10-page record, and no one's reading you that over the phone. And each record, each line on the record will have information like default picked up. You'll know their history of defaulting.
It does and it doesn't, because each one of the states are different. And I'm telling you, when you read some of those, I have no clue when they were arrested, if they ever saw a judge, what the outcome was or anything, because it's not spelled out as neatly as ours is. But it took ours a long time to get. So when you looked at the criminal record, you could actually figure out what was going on. But And the thing is, with the requirement to 24 to 48 hours holding, that's excluding weekends and holidays. But yet if, like for Thanksgiving, where they have Thanksgiving and the Friday off, the court is required to hold bail hearings on the Saturday because of the amount of time that they'd be held. So
And that's at the courthouse is open on Saturday during those occasions.
I don't know what they do. I'm having a funny feeling that that's probably all done video.
Okay.
In other words, they have the ability to do it.
And I think what the committee's picking up is there's a lot of compartmentalization. In other words, you know what you guys do, but beyond that, that's really, what they do. And then what happens before they see you is something else. And then what you each do is a little bit different.
Absolutely. And if you listen to us, each one of us came on at a different time frame. When I came on, my training was I had to follow a bail commissioner to see 2 bails. First one was a B misdemeanor, which is a non-jailable offense. Doesn't need a lawyer, so what you need to know in a circuit court bail order, 4 pages. The next one was a civil bond, which was a 1-page. At that point, I was blessed, go forth and have fun. And it was a school of hard knocks. The training was catch as catch can. Some of it was good. Used to be when they changed the paperwork, that's when we'd get training and we'd be trained on the paperwork, what the court was looking for in the paperwork. And that was what they were concerned about. After the legislature put in that we required training, the first training we had lasted 21 minutes. It was over a video. I sat at the Concord District Court. Judge Kelly was presiding, and the hookup or link didn't work. So needless to say, it was a disaster. And then we at least had 2 judges sitting there and says, well, guys, we're here. Do you have any questions? And then some training happened. And particularly where I'm in Franklin, I'm the only bail commissioner of record that was basically came out of Franklin. The others are out of Laconia or out of Concord that are coming up and helping and covering. So the thing is, I usually end up either in Concord or in Laconia. Now, last year, Laconia's training, we had the clerk, 2 deputy clerks, because it was both Franklin and Laconia, but they share the same clerk, 2 judges, and the bail commissioners. We went for almost 2 hours, and it was the best training that I've had in basically 7 years. So the thing is, it's again, catch as catch can, depends upon the clerks. And sometimes we get the administrative office of the court where either the administrator of the Superior Court or of the Circuit Court gets involved in the training and a little bit more actually happens. It's like the ID card you said we were supposed to get. I got it in an 8.5 by 11 page with this little tiny thing up in the corner that looked like someone in the kindergarten had done it, and I was told to use that as my identification as a bail commissioner. With all due respect, my business card looked more professional than that. So the thing is, just because the law is made doesn't mean when it finally gets down to the people that are doing the work on the ground that it has the effect that you want it to have. The things that I think you heard Judy mention and others, you want to think of the consequences. If you take and add domestic violence on there and you're talking about the misdemeanor side of it, sometimes that's telling you the nature of the offense. Take, for instance, I'm in Bristol and I'm bailing someone and I decide to hold them. Or not. There's that chance. But the way the way you've written the law, it says shall. So it's a snowy night, 1 officer on, and he's got to go all the way up to North Haverhill to where the county jail is. Or if you get someone in the bottom of Coos County in the middle of a snowstorm, they got to go all the way up to the top of Stewartstown, almost up to the Pittsburgh town line where the county jail is. There is an impact on the rural side of this in the small police departments where there's only 1 officer out, if you're lucky. And if it's after 11 o'clock, 1 o'clock in the morning, they may be on call, covered by state police, and we know they're severely understaffed, as is the county. There may not be anything until that officer gets called out and finally gets there. So there's a lot of things in play that you want to take a look at the list. I would have referred you back to the website for bail commissioners. There used to be a bail commissioner's manual out there. I still have my 2016 that I printed off, but I knew I could get the 2020 that was out on the website. Well, probably about 4 or 5 months ago, they took that down. So I'm still using my 2016. But inside that book, there are 4 things that are listed that we can't write bail for. And some of it's the homicide and some of those things. And the rest is left to our discretion. And I think the key to it, and everyone keeps coming back to it, it's training. And so that there is a consistency throughout the state. I'll just throw this in here just to add a monkey wrench in, since you're going to talk to finance. There was a thing to put on 15 magistrates to replace 100 bail commissioners, to do it basically for nothing and provide all their own equipment. And there was a caveat that you would hire someone to train the magistrates. The money has already been talked about. So if you took that money, use that person to train the bail commissioners, and then they got, I think, $1.6 million to pay for the 15 magistrates, the support staff, and their benefits and all of that stuff, and gave that as seed money to go into the court system so that they could pay the bail commissioner for everything we wrote. Every 2 weeks, send us a check. At the end of the year, give us a 1099. We're still an agent. We're not an employee, and everyone's happy. And your bail commissioners are getting paid at whatever the statutory rate is. But with the postage keep going up and gas keep going up, you're probably going to have to look at that $40 rate, because you stop and think, we're not getting it 100% of the time at this point. And you speak about equipment. I'm now on my second iPad, 12, the iPad Pro that I do my bailing on with the, the fancy keyboard. I've had to buy 2. I'm on my second portable printer because I burned my first one out. So the thing is, those go at $450, and the iPads are almost $1,000. So the thing is, these are all things that we provide for ourselves. I'm always going out and getting a case of 10 reams of paper, so that I have the paper on hand to print all the forms that I use, because I print them as I go. So I mean, you got a dedicated group out here, but all of a sudden we start reading that the legislature wants to do away with the bail commissioners. Judge Lynn, who was the Chief Justice of the Supreme Court, the Superior Court, now legislature, wanted to put on 3 circuit court judges and do away with the bail commissioners, because that'd be enough to handle it. So, and it gets kind of discouraging for those of us that get up 24/7, 365. It's like this morning, I got a call at 3:15 in the morning to do a bail, and I still had to get up to be here because I thought it was important enough to be here to give you information that I think that you need before you make decisions about what bail commissioners are. And I'm glad to see you haven't called us bail bondsmen. That's the first time in several years coming down here since 2019 that we haven't been referred to that, because there was one put in by a senator of one of the bail commissioners specifically to help the bail commissioners, and it said an act relative to bail bondsmen. And then it was amended, and bail commissioners.
I can't speak to that, but I can tell you that we at least read the law before we start talking about changing it. So you won't be called a bondsman in here. And we appreciate it. And I hope that you heard my earlier statement. This committee has no interest in attacking the commissioners. We don't blame the commissioners. This is a systemic issue. The commissioners are a huge part of it, but it's not just the commissioners. It's all the other agencies as well.
And that's the part when you go into, you have to remember, as a bail commissioner, I'm making a decision at that point in time. That's a snapshot of what I'm seeing, what I've read, what I've heard from the officers, and I've gathered. Sometimes it's like pulling eye teeth out of a saber-toothed tiger to get the information you need to really do a good job at the bail. And then it goes to the court. The prosecutor, the judge, the county attorney, they're all involved in that process. I hold them in preventative detention because I'm hoping that the judge will hold them. And in the circuit court, at least I've been able to tell the judge why I held them. In the past, pre-2018, if I held someone, they'd usually be a week anyway before they had a bail hearing scheduled. To change that, now they're usually out the next morning. So the thing is, it becomes a revolving door. And the bail commissioners always seem to be the punching bag because we were the one that did the paperwork. And it's like, the paperwork is the paperwork, as she said, and if you actually got to see the forms, you might understand is this is the paperwork that we have to give to the court, and that's all we send them. And like I say, in the circuit court, at least we have the opportunity on the bottom of the page to say why we put them. But it's only 4 lines, and it's hard to get everything in 4 lines.
Agreed. And we do appreciate the reference. We will be circulating those documents amongst, we're going to make sure that we see what it is that you
Yeah.
actually.
Just
have to
make
fill.
sure you leave telebail in there. That's a good thing.
Yeah.
Because otherwise there'd be police departments that would be still making phone calls. I got a call from one over in Rochester. I was the 20th call they placed for find a bail commissioner.
So bail commissioners, as a bail commissioner, you can just say, nah, not tonight. I'm not taking it. You can decline.
Yeah.
So, yeah.
Well, some just don't answer the phone, but I was always taught, if I know what it is, I answer the phone and I'll tell them why.
And are you on call 24/7, 365? So
That
on a
phone call-
holiday, if you decide, you know what, I'm gonna have a couple of libations to celebrate, you've kind of taken yourself off the market, and no one knows if someone else is there to fill it. And
As the expression goes, that's not my problem.
yeah,
In other words,
exactly.
I was set to bail out of the Franklin district. It's a small area, but it kind of got up into Grafton County, went into a little bit more in Belknap County, a little further out in Merrimack County. And then it kind of became the 6th Circuit, which goes out into Hillsborough, down into Hooksett, and kind of taking that out. And then COVID hit and it became statewide. Because once state troopers start to learn that someone that's willing to do the paperwork and set up and figure it out, they pass the word and it gets into police departments, dispatch centers, and your phone keeps ringing.
The punishment for doing your job.
Yeah.
Any questions? Oh, I see a few. Okay, Representative Wheel. Oh, Representative Stone.
Thank you, Mr. Chair, and thank you for taking my question. From an operational standpoint, since you've been doing this for a while, do you think it's feasible that since New Hampshire has 13 cities and over 200 towns, that 15 magistrates will be able to keep up with the caseload of what you currently have as approximately 100 bail commissioners?
Well, here's the cold hard fact. You got 15 people that are going to work Monday through Friday from 8 to 4. And you got 100 people that are working 24/7, 365, and it doesn't cost the state anything. Run the numbers. We are cost effective. And the thing is, everything that I hear is one part of misinformation because people don't understand. The biggest problem for us is communication with the court and being able to get a hold of somebody at 3 o'clock in the morning when I've got something that makes absolutely no sense because I can't read what the judge wrote. That's why I went out and I got the iPad so there was no thing. And so I can't tell the defendant when I'm trying to release him what that is. Because I can't read it. And yes, we've complained up through the administrative office of the court and numerous times, and we don't get phone calls back. They just plain don't answer us. I know we're lower than whale crap. We're at the bottom of the pecking order. We understand that, and we deal with it. But, you know, the thing is, the only time I think I'll hear from them if I screw something up, maybe.
So that brings up an interesting question is the very fact that you're having to decipher handwriting. It's that it's not electronically printed out. You're actually reading like doctor's prescriptions at 3 a.m.
No, doctor's prescriptions I can usually figure out because it looks like my handwriting. This is even worse. I mean, it's like a pen, just pencil. One writes in pencil and it lays it on the side and it's kind of flowery and it just becomes a smudge across the paper. You can't read anything. We had 6 people trying to figure it out at the jail one night. And it was someone that we really didn't want to release, but we couldn't tell them what they were supposed to do and where they couldn't go because we couldn't read it. So we went back to the police department and we got the original information. We were able to, in other words, we made it happen because we know that there's other ways to do it, but it's not the right straightforward way. We should have basically a clerk available to us or a judge available to us 24/7 like the police do. So if we get something that's never happened before, how to deal with it, we at least have someone to run something by. We used to have that with the older judges that have since retired. The newer judges, no, hey, that's your job. You set the bail. We don't do that, so I can't advise you. I'm not looking for advisement on what I'm going to do. I'm looking for process, and you deal with process. So that's some of the challenges that we've had. Not everyone has it, but I'm also an advocate for, in other words, when I go down, when someone's coming into the jail with, cash bail, they wait an hour usually before someone gets there, but they've had to wait until they've processed all the money through, made sure everything was there, that they weren't the protected party or someone they had to stay away with before they call us. So once we get down there, so I'm more concerned about the bailing party that's come down or driven up. We've had them come up from Massachusetts and they couldn't get a bail commissioner, and they had to go away and come back another day because of that. There's all kinds of things that are going on out there that shouldn't, but they do. And it's like, it's the totality of what you need to look at. But I think what you've heard from some, take a good hard look at the laws and see how they're going to affect anything north of Hooksett. Because as you start to go up north, or you get over to the western side of the state or the eastern going up, things change dramatically once the population goes down. Is the tax bases that are supporting those police departments, they're not very large. And some of the courts are not full-time courts, they're part-time courts, so they don't have a regular schedule. At least with Superior Court, we know, but the others we have to guess, especially if the police officers don't know. That becomes challenging.
So you could set a court date for a defendant to appear that there may not even be a judge there that day.
So what I do is I cheat. I find the biggest town that's 24 hours in that court, and I call and give me a valid court date. So at least I know that on that date, there's going to be a judge there. There may be an unhappy prosecutor, but at least we get them in to see the judge on a valid court date. Or sometimes what the court will do is they'll mail a new court date to the person because they'll realize that there is no judge available.
It sounds like perhaps new judges need to shadow a bail commissioner instead of just
No, it goes back to the thing, it's training for all of us so that we all understand. And then sometimes it may be, as the old adage used to go, you get the judges, the bail commissioners, and the police and the prosecutors together and have the conversation. And so that way everybody gets to hear the same thing at the same time, and it makes things a lot easier for everyone.
Don't worry, you'll be back. Representative Wheeler.
Thank you, Mr. Chair. This seems like such a thankless job. I'm curious as to what initially attracted you to want to become a bail commissioner, and how we could get younger or more people to do what you have served the public to do for the other last however many
To
years.
be honest, nothing actually attracted me to being a bail commissioner. I'm a retired police chief, and I had 3 police chiefs come to me and say, we need a bail commissioner. You've been retired a year. Can you help us? How could I say no? Because having been a police chief, I was at the mercy of bail commissioners because they were unavailable. So it was like, well, yeah, that's how I did it. But on the flip side, I'm getting older. This forces me to keep my brain active. I have to stay up on the statutes. I like to read them so that I understand the nuances and the things is what I can do. And after the dust settled on the 2018 bail reform, I went back and I looked at the law. The law hadn't really changed. It was the attitude of how we were looking at things had changed. And we just started sliding things in because I was asked to go down to Manchester to bail. And one night I was there, I sent, I think, 3 people preventative detention to Valley Street Jail, sent one on 5,000 cash and one on 10,000 cash. And I didn't get a note from the court or anything. So the thing is, it's doable. But the thing is, we have to justify what we've done. And I have to be able to explain if I get called by the judge why I did what I did. So the thing is, everything we do is, you got to do it objectively. You can't be subjective about it. You got to have the facts in front of you, and based on those facts, you make the condition that certain things need to be done. And if you can't quite get them to jail, it might be cash bail, might be the better way to do it. Because if they can raise the money, they don't. But if they can't, they still go to jail. Then they see the judge. So the thing is, the end result, you get almost the same thing.
I appreciate your testimony, and I'm more sure we'll be conducting these hearings first next month. So I'm sure we'll see you again, and we'll have more questions. Oh, I'm sorry, yeah, Representative Gathright.
Thank you, Mr. Chair, and thank you for taking my question. I'm just curious because I remember that there was a bill from the Senate where they wanted to make sure that the commissioners got paid. And I know that the commissioners came and basically told us not to vote for the bill, which we did listen, and we basically killed the bill. But I'm trying to understand why was it that the commissioners did not want the state to intervene to make sure you received your fees of $40.
It was for mileage. A senator was seeking to pay bail commissioners mileage. The bail commissioner community, other than the one constituent, felt as though we needed to address being paid, not increasing the fiscal note that will be attached to if you start paying mileage that we're not collecting. One more thing, we're not collecting. It increases the fiscal note for anything that we're looking for to be paid by the state. So that's why the bail commissioner community said, let's fix and get us paid first before you start increasing fees or adding fees that we are going to, that we want to be paid for.
So you felt like it was going to jeopardize getting paid for your bail fees in the first place by asking for even more.
And then they also, the flip side was, can we bring it up to $50? No, leave it at $40. Just pay us the $40. But that was before the last 3 years of extreme expenses. So the thing is, you're probably going to have to revisit that if this thing doesn't change. Because the postage when I started, I think was 40 some odd cents. It's now 66 cents. And the thing is, you talk about nickel and diamond, or I've showed you that I'm over $51,000 in the hole since I've been doing this. So the thing is, plus supplies and everything else, that $40 isn't $40 in reality. And then when you figure only 62 to 68% collecting, that's part of the challenge. So to go back to your question, again, we're the only ones in the judiciary that don't get paid on a regular basis. And when we go out to do the work, we don't know whether we will or we won't. Because I was told, at least, I can't ask, do they have the bail fee? Because that's grounds for my termination, I was told. However, I know that there are bail commissioners that ask and say, no, I'm not coming out. And they hang up.
Just so I do it, I want to do a listening check. You have been doing this for 7 years, just the bail.
7.5.
7.5. And in 7.5 years, you are $51,000 in the hole in just bail fees, not talking about your own expenses and mileage or anything else.
Yeah, $51,039 to be exact. And that was as of 9/13/23. It's gone up since then.
Thank you. Representative Gathright, did you have a follow-up?
So with that said, have you actually talked to anyone in the Senate about that $40 fee in terms of a bill to address that issue, since you did not want the one that you said was related to traveling?
That was mileage. Yes, we were told that it would be taken care of.
How's that working out?
See, that was the nicest way I think I could put it, and not put
Okay.
my foot in up past my kneecap.
Just curious. Thank you.
Answer your question. I spoke to Melanie Levesque, who I think you probably know. She was the chairman of one of these groups. Bail Reform Study, Bail Reform Study Committee. And she was all in favor of getting us our money. But it was just trying to when the committee it just got so far afield and started concentrating more on bail reform and other extraneous things. I remember the chief in Rochester was on the committee and he testified, and what was he said something about we might as well turn this whole thing over to Fish and Game because it's just catch and release. And I'll never forget him saying that, because it is. I mean, you PR somebody and he PR'd, they PR'd some guy that was doing burglaries 8 times one day and kept catching him again and again and again. And that's when it started that, if it was 3 times the same thing, 5 years, straight to jail.
Thank you.
Just-
It's all kind of reactionary. It's not, it's not ever been, I don't think, well thought out.
That's what we're trying to do.
Just so you,
I compliment you on finally getting to this stage, but it's been years.
but again, a lot has to do too is the police departments, if they happen to ask, can you hold this person, and then actually tell you why and not have to fight to get it out of them. Because I had one where I bailed up in Haverhill. Gentleman had all kinds of stuff and they wanted PR bail. Had no criminal record, had nothing. So, I mean, there was, just nothing that you could say that you could meet the requirements to hold him. Well, the nice thing was, after I let him out on conditions, he must have found a spot to hang out until he could go pick up his vehicle, which was on a 24-hour hold or 12-hour hold. And he got in the car and left Haverhill and went into Piedmont. And he got stopped there. And the chief happened to stop and he noticed he saw the bail paperwork, so he called me. He says, I've got this person. I said, for what? And he said, would you be open to holding him? I said, well, there was no doubt about that. I just told him he couldn't do all of that, and we haven't even got 12 hours here. So he went up to the Grafton County Jail. So the thing is, a lot of times it's situational.
It sounds like that was luck. I mean, had he not seen the bail paperwork, to know that guy was on bail.
Where he called me. So,
Yeah.
I mean, otherwise, another bail commissioner would have been in the same thing. There's no record. With no record, it's hard to. But then again, within 12 hours, you got a little bit to build something, depending upon the nature of the crimes, too. And, some things they're what you call no-brainers. Like the door nailed up, that's kind of like, no, you definitely need to see somebody, and it's above my pay grade. So preventative detention. And it seems that he was going to go back and try it again. So that goes to show that, yeah, okay, no, would have been a right call.
Thank you.
You're welcome.
All right. Thank you for your testimony. I believe that's it for the bail commissioners. And I think you'll agree with me. We've had a lot of enlightening testimony and a lot of information. So I'm going to give everybody a little homework before we meet again. Yes, please. Have a.
This is what, and you can copy it if you want.
That's what we're going to do.
It's just what I give out to all the telephonic towns.
Okay.
They call me, I fax that, or I don't, I email it to them.
Okay. I appreciate that.
Just so you know, the circuit courts want faxes. They don't want them.
Okay.
Because half of them don't have anybody, they all have their own emails, and they
Yeah.
don't have an email the bail. The bail on it.
So yeah, they have a fax machine spitting out. Somebody has to pick it up. Okay, thank you. So for your homework, I'd like you, everyone, please, if you could, go to that website and look at those forms so that we can have an intelligent discussion tomorrow about those forms, and I'll figure out tonight where to take us tomorrow. I think we've heard enough about the crimes. I think we need to. One thing we haven't discussed is flight. We've talked a lot about dangerousness. I'd like to discuss flight, risk of flight. There's the 2 grounds someone could be held on: that they're a danger to themselves or the community, or their risk of flight. So we haven't heard much about flight. So tomorrow we're going to talk a little bit about that, and we'll see where that starts. That conversation takes us tomorrow. As I said, next Thursday, we have a representative from finance is going to come in here So I'd like to have a kind of a conceptual idea of how much money we may need and what for. So far, we know that we are going to definitely, and I hope you'll all agree with me that we're not leaving here unless we have these people paid. I'm done with that. So that's going to be part of it, and we're going to be asking for some money for the technology piece. I think we may have to temporarily fund a few positions in the court. And the way that would work is we would ask them to tell us how much it would cost for X, Y, and Z employees until your next budget year. And then it's up to you to put it in your budget to redo it. Right. So we're gonna have to put together a ballpark. And then as we get towards the end of the process at the end of October, I hope to put some real numbers together to ask for and justify. And let's leave this better than we found it. And so we don't have to talk about it anymore. Really, next year we could just maybe deal with crime. Yeah, the homework is to look at those forms that she pointed us to that have. Well, no, if you go to there's a link. I'll ask someone if someone gets it could. Yeah. Okay. Oh yes.
Just go to like New Hampshire. That's what I was just looking for.
Since it's, I'm going to ask our committee assistant if she'll print it out for everybody. That you don't have to. You spend enough money. We have our own reams of paper we can use. Yeah, if you want to, because I didn't see her. Yeah, that would be helpful. I appreciate that. Thank you very much. And anything else that occurs to you overnight that we haven't heard, bring it, and we'll talk about it. And with that, I think that's all the homework we can do. We'll have some more homework over the longer period till we meet again on Thursday, and we'll decide where we're going to go next week. Yes, sir. Senate Bill 112 from which year? Brad, could you send us a link for that? I appreciate it. Thank you. Does anyone else have anything else to say before we break? Yes.
I just want to apologize to our clerk really quickly because I know he's watching. I did not eat this muffin and I just brought it in here. I will not bring food into the committee room.
I didn't even see it. I just saw it. I was like, get that off.
I appreciate it. Thank you. Never bring muffins unless you have one for each of us, and only pass them out during the break. And Mr. Clerk, I'm sorry. With that, everyone, please enjoy your evening.